Mic check, 1, 2, 1, 2, 1, 2. 1, 2, 1, 2. 1, 2. Mic check, 1, 2. Good evening, everybody, and welcome to another edition of The More You Know. Would you please stand as we go to God in prayer? Gracious God, we give you thanks for this is the day that you have made. We thank you that we have gathered this evening, Lord, and we have gathered to be equipped, empowered, and educated. Lord, we give you thanks for our presenter, our facilitator, Sister Kimberly, and we pray, God, that you will continue to anoint her. We thank you for the Calvary Moravian Church and for these 190 years. So, God, as we continue to grow from strength to strength and to grow from strength to strength, we pray your blessings on each and every person. We honor you, we love you, we thank you, and we look forward to a wonderful discussion. In Jesus' name we pray, and everybody says, before you sit, just turn to somebody and say, good to see you in the house of God. Just, introduce yourself to somebody, smile. We are family, and it is good to have all of you here in the presence of Almighty God. You may be seated, sisters and brothers. As I welcome you, I also want to take this opportunity to welcome those who are streaming this broadcast and those who will be watching this at any point. You have joined us for the second part of a three-part introductory series entitled The More You Know. Can you say that with me? The more you... Can you say that one more time? The more... All right, so we began our journey. Anybody can remember what was the first thing we discussed? I see what I just didn't remember. Buying and selling property in Barbados. All right, and this is part 2 of the 3-part series. The third part, we are crystallizing that, but I can let you know for sure that the third part will be to plan your pension. Plan your pension so that we can understand what's going to happen when we get to that wonderful day, should the Lord bless us, that we get to retire. So we still want you to spread the word, tell a friend. And then what some of you have been doing, which I so appreciate, you have been now feeding us some other topics that you think would be helpful in terms of the continued education process. And so we're taking those suggestions on board. So please, at the end of this, write us, send your feedback, send some suggestions. We'll be more than willing to have this. And as you know, all of this is a part of our 190th anniversary. Could you put your hands together for this celebration of 190 years of work and witness of the Calvary Moravian Church located in Roebuck Street, Bridgetown, St. Michael, Barbados. This evening, sisters and brothers, it gives me great pleasure. I get to actually do this for someone who would rather be behind the scenes. And I must let you know, she said, Rev, you sure we got to stream? I said, yeah, we got to stream, but that's the type of person that we have facilitating us this evening. Kimberly Aline Pinder is an attorney at law with 10 years of experience working in general legal practice here in the island of Barbados. Admittedly having no specialty, her practice includes contentious probate, estate planning, civil litigation, property law, family law, administration of estates, and corporate law. Kimberly is a graduate of the University of the West Indies Mona campus with a degree in media and communications studies with a minor in political science. She then completed her LLB at the University of the West Indies Capefield campus and completed her professional training at the Hugh Wooden Law School. She currently holds an LLM in corporate and commercial law and an EMBA General Management from UWI Capefield campus. She is talented. Would you put your hands together for that? Really talented and qualified. She works as a sole practitioner. Her chambers is KAP Legal Services in Salters, St. George, and is also the General Counsel for the Student Center and Dev Carib Limited. She also sits on the Board of Directors for the Barbados Public Workers Financial Holdings Limited. Her aim is to bring a human touch to legal practice and places clients' care above all else. Her mission is to empower clients to navigate the world in a manner that leaves legacies for those to come. In her spare time, she loves to spend time with her family and small circle of friends and doing nothing related to law. That's good. You got to get a balance. Ladies and gentlemen, will you put your hands together and help me welcome our facilitator this evening, Kimberly Aline Pinder.
Good evening, everyone. I am really excited to be here. And this is my favorite topic to talk about. And I hope that by the end of this, you understand how important it is to have your business in order during your lifetime and for after. You cannot rule from the grave. Let's start there. Let's say it together. We cannot rule from the grave. So that's why we're going to take, let's say, practical steps to ensuring that your affairs are in order. You don't be afraid of the process because you're doing it for your loved ones. You love them during lifetime, you love them after. There's no obligation to give your children, but we give them anyway. And we ensure that we leave a very easy, uncomplicated estate for your family members to deal with. We understand where we're coming from this evening then. All right, so with that in mind, I'm hoping that we could start, but nonetheless, I could talk about this for the whole evening and don't look at anything. So if one will be me, I'll be you. All right, here it is. And for me, I like interaction. I like you to ask me a question. Please stop me. I may walk around, but I want you to, this is your session. I'm here for you. If you have a query, if I've said something that you don't understand, please let me know. I like to bring a human element to a very academic subject because we deal with humans every day in our practice and we are nothing without you. So if you don't understand, I have failed. So let's start from the top. Wills. An outline. And let me just add on estate planning because it's part and parcel of estate planning. So we're going to meet Bob today. And Bob has contacted KAP Legal Services or any of the 1,000 other attorneys. And he says, he's walked into my office, he's given me a few instructions. Bob wants to make a will. Okay? That's Bob for today. Right, so Bob, let's give his profile. He's not married, and he's thinking about marrying Susie Kabluzi. The millennials know who Susie Kabluzi is. He wants to understand how marriage will affect his will, why he has to make a will, what if he gets children, what will happen if he doesn't make a will. Bob is at present, he's 25 years old. He wants to know if he's old enough to make a will. Can he make a will? Okay. He owns a couple properties, so he's doing well for himself. He doesn't want Susie Kabluzi to get anything, even if they get married. All right, so, pardon? Oh gosh, hear the words, prenup. Well, we know the status of prenups in Barbados. You know, the court will have regard to them, but it's not something that we actually practice or is it legislated for. But if after you marry and you do a postnuptial, we'll talk to you because we understand then that that was a contract. But the court will have regard to a prenuptial because they will say at the time you signed it, you were a consenting adult, you understood, you had independent legal advice, and therefore they will enforce it. Let me say will. They may enforce it. Okay? All right. So that's Bob. So Bob has given me those instructions. Anything sticks out for you? What Bob has said? Talk to me. He didn't want Susie to get anything. All right, so just remember that. And Susie is going to be his wife. And you're going to, and she is aware of what he has, but Susie coming in with something too. So Susie has to be protected, and Susie has to be thinking about her estate planning as well. So I want you to remember those points. He's 25 years old, he's not married, and he wants to make this will. So during this presentation, dealing with Bob, we're going to inform you, I'm going to inform you about the reasons for making a will, why Bob should make a will. Age you must be to make a will, and you've already understood that Bob can make a will at 25 years old. I'm going to give you just a nature and formalities, which is important, and the different types of wills that you can actually make, because there are different types. The property that may be disposed of by this will, and persons who must be provided for in a will. And I want you to remember this point when we're talking about Susie and Bob. Revocation of wills, if you can revoke a will. And at the end of the presentation, I want you to have a general knowledge. I cannot tell you everything about a will in this session, because everyone is going to come with their nuance. Everyone is going to come with a different dynamic. It could be blended families, it could be on your own, it could be a widow. So I want you to remember, I can't answer every question here, okay? And I want you to appreciate the importance of a will, and hopefully be motivated to make a will. I don't want any of you to put on your pajamas tonight. I want you to understand how important it is to have this in place. Because you see, the first practice point that was mentioned, contentious probate. It drains your estate. By the time you finish, you have paid the attorneys probably half your estate's worth. And then you have to sell. So no one gets to enjoy it. Okay? So let's start. Why should Bob make a will? So it's essential to make a will because you will decide who takes control of your assets after death. So assets could be what for you? What's the first thing? House. What else? Your car. Money. Shares, your investments. So you get to decide who will take control of these things and who will spend them, essentially. You decide who gets your assets and the proportions, because sometimes you might give a half share to a cousin, a half share to a brother, a quarter, or I've seen even an eighth or 16th of piece of land, but we don't do that at KP Legal Services. So you make provisions for your children, your relatives. Some people give to charities, pets. I've seen a will where they care for the cat, you know. You decide the arrangements for your funeral as well. You know, people say go and pay for your turnout. You can put it in your will as well to leave your specific instructions. It's essential that it is divided up according to your wishes. And that is important. So when you're given instructions, and I may be jumping ahead a little bit, but I want to say this. When you go to make a will, it's important that you understand your bounty. You understand what it is that you are actually devising or giving away, for lack of a better term. So you write a list. I like to tell my clients, you come in to me to make a will, please write a list. If you have one car, one house, one dog, one cat, whatever, write it down so that you see for yourself, okay, this is what I'm dealing with, this is how, when I go to the lawyer, this is what I want her to distribute to my family or to whomever. Okay, so make a list. Be aware of what you're devising. And for all of those persons who may be a half-share owner, that too is important. Who own companies, that is important because your shares can also be disposed of, okay? So if you don't make a will, what happens? What do you think happens? The law steps in for you. You gotta get letters. Hey, Letters of administration. So yeah, so otherwise succession law cap 249 steps in. And it will take effect and your property may be distributed in a way that you may not be comfortable with or you may not have wanted it to be distributed. You understand? And we can get to those sections a little later. And I want to say that don't think of this as black and white. I exist in gray. I like the color gray when I'm dealing with these types of things because whilst we may say, oh, but if you don't do it, this can happen, sometimes it's best to leave it because if you have someone with a mental incapacity, you wouldn't go to them at that point and try to make a will. But you can because there are ways in which you can do that, but we ain't get there yet neither. But just let you know, exists in the shade of gray. There's a way that you can do it. But sometimes some persons really, it's unavoidable for persons not to be able to make a will at the time that they're at in their life, okay? It provides for order. My father always says you must do things in good order. Good and decent order, and that is important. And here's the thing that we would hope. We ensure that there are no family disputes. Let us all laugh together because you would know that even if you draft a will can be set aside. Okay? Best laid plans, something can happen. Okay? Wait now, that my mother asking me that. Sorry, we have a mic runner. Miss Aline, I can't hear you. What will cause it to be set aside? There are many things that can cause it to be set aside. Specifically, if it was not done in compliance with the law. That's number one. Let's start there. If I did not have the requisite mental capacity. If it was not signed or witnessed the way in which it should have been under the law. If I was not over the age of 18 at the time of making the will. Or the niggly thing is if, I mean, we're going to come there, but thank you for bringing it up. If Bob marries Susie and they have children that are over the age of 18, they don't have any disabilities, they are out of the house, they can fend for themselves essentially. And Bob does not provide for Susie. Do you think that the will can go through? Would it be valid? It would be valid, but it would be subject to Susie's interests. We call a spouse's legal right, and that is protected. So there are three classes of persons that are protected under the Succession Act when you are drafting a will. And I ain't gonna go into that, but that is one of the ways you can have the will set aside to subject to her interests, satisfy her legal right, which is half share for our spouses, and then you will apportion the gifts under the will to everybody else. You following me? So if I had an incapacity, God forbid, like dementia or Alzheimer's, if care was not taken when the will was being drafted or a doctor wasn't present, Bank and Goodfellows is a case that I follow to the T. If you have someone with an incapacity, a mental incapacity, doctor should be present. Because we have these things called lucid intervals. The only person that can verify a lucid interval is a medical doctor. So if you do the will and you know your mom or dad had that incapacity, like, well, and that signature look kind of funny, there are things that will make persons pause, like, well, maybe it was done under undue influence then, or maybe, you know, at the time she was not in her right mind. So there are these factors that we have to be careful of. So that is a good question, Miss Aline. Thank you. I hope I've answered it. Any other questions after that? All right, let's move on. You should review and update your will, and I'm a strong proponent for this. Review and update your will. The will that you drafted at 25 may change. The players may change. The beneficiaries may change. Your life may have changed. Especially when you become 60-something, you might want to look over it. You may have acquired more assets. So you may need to look over your will. So that is something very important. So for all of you who have an existing will, just take a peek at it. I tend to call some of my clients and say, you know, how are things doing? Not gathering business. Just come in and let's have a talk. Yeah? Yes, please. You can review it up until the day before you die. Pardon? Uh-huh. You'll come back and change it. And I say that with great caution. And the question was, what period of time do you have to change your will? You could do a dying declaration as well. But here's the thing. If you are 86 years old and you came to me in, say, 2018, and you said to me, okay, Kimberly, I'm drafting this will, and I am comfortable with it, I'm not acquiring anything else, I just want to live out my days. It may raise suspicion when the week before you die, you come to me. But you have the right to do that. So I wouldn't say there's a bar to you coming or there's a limitation. I just want to say be careful, right? And that's more so for the practitioners than for you. All right. Right, so you look at the circumstances where there may be a change in circumstances, addition of a child to family or marriage. So let's look at the nature of a will. A will is an instrument containing the wishes or declaration of a person called the testator. So you'll hear that term being bandied about, testator, with respect to the matters which he or she desires to take effect after their death. So this is why Bob has come. He wants to put his wishes in writing because it makes no sense saying, well, Granny told me before she died that she can give me the house. It's not in writing, right? So we have something called a codicil. So if you come to me and it's just a small addition, I don't normally like to do them, but if you want me to do it, I'll do it. A codicil is generally supplemental to a will. Same formalities must apply. Requisite mental capacity over the age of 18 and must be witnessed in the manner as prescribed under the law. So a will is made for the purpose of disposing of property and it takes effect at death. So a will becomes what we like to say a public document upon the death of a testator, okay? A will is that beautiful word ambulatory without fixed effect. And that's just repeating what I just said. It can be altered or revoked by the testator at any time during his lifetime and capable of operating on property which becomes that of the testator after the will has been made. Sometimes people don't put everything in their will. Sometimes they will leave it to the residuary. Y'all ever heard that word before? The residuary. So the residuary in a will, anything left over that I did not dispose of at the time that I made my will. So sometimes people are pretty comfortable, well, I left it to the children, I don't need to come back or dispose of. But I prefer, especially if it's an asset, like property, house and land, I like to advise you to come back in and amend your will, right? And let me just say this. There are attorneys that would tell you something different. Good for them. This is what I see in practice, and these are the things that I have added to my practice to make life easy for you as the client or wherever you may go, even if you just come for advice. Because we will say, well, man, left it to the residuary. Yeah, but suppose the beneficiaries in the residuary have passed, or suppose the beneficiaries in the residuary don't get along, okay? Or suppose we got 3 people, we splitting the house in 3, how we can work this out, how they holding it. So I prefer to be very specific, land area, what it contains, where the content's going. I just like to be very specific to make the person's life, the executor's life easy. Yes, please. Oh, I know you. Yes, please.
In the case of what you just mentioned, where you had the 3 persons and splitting the house, can you also specify that the house be sold and whatever money be spent?
Of course, of course, of course.
Thank you.
Yeah. So you understood the question and the answer? You can give directions in a will that the house be sold and the proceeds of that sale be distributed amongst the beneficiaries. Thank you, because this is hot. Thank you. You can also advise that a valuer be assigned to value the house at that time. That is what I also include in there, because you have to agree on that purchase price as the beneficiaries. So the will should also state that and the cost could be shared by the beneficiaries, but it's important to say that it is to be valued so that everyone can say, well, it was fair, it was unbiased, it was transparent. All right? Very good question. So it can be altered, but it is irrevocable during the lifetime of the testator. If it is irrevocable, is another type of document. Sorry, we have another question.
The question I asking is, suppose the person, like the beneficiaries, like say there were 6 beneficiaries.
Oh,
and 5
gosh.
had passed away.
Some pass away?
Yeah, what will happen?
Well, what will happen is the estate of the beneficiaries would then benefit. So let's say we have six siblings.
Yeah, say 6 siblings.
6 siblings. It is a house in question.
No, but, yeah, well, it's house and general.
General.
Like house, everything, like money, everything like
Right,
that.
right. So what will happen is the estate of each deceased individual will benefit. This question got some depth. Hold on. What happened?
Huh?
What, you can't find them?
No. Why I ask that is, it can happen that somebody passed away.
Of course.
That you had in the estate. So I thought it would be like the...
It will go down to everybody else remaining?
No. I thought it would be the executor of the will would be dealing with that.
I feel that you asked me 2 different questions.
All right, suppose these people are passed away.
Right.
You have one person left back.
Right,
And there's an executor of the will.
right.
Is the executor of the will able to distribute?
To the estates of those persons.
Oh, okay.
So what you would do is you will confirm who's the executor or the administrator of those estates, and you will then devise and to transfer, let's use transfer generally, transfer the assets or whatever is left to those persons surviving. So their families will benefit.
Thanks.
Y'all understood that question? All right. So because someone has died, it doesn't mean that the family wouldn't benefit. The family would still benefit as if the person had survived the testator. Okay? Formalities, right? How do we make a will? Person must be over the age of 18 or have been married, because you know there were some people who were married at 16 and you know must be of sound mind. And that, let me repeat that, must be of sound mind. And this must happen at the time of giving instructions and at the time of execution. I'll leave that there. Sound mind requires that the testator is able to understand and recollect the property that he or she has, understand and recollect the claims of those by whom his will he is excluding. So he must be aware that, okay, if I do this, I'm leaving out this person or including this person. That is important. And understand who he is giving the property to, and if it's one or more of the objects of his regard. And we spoke about this. Certain disorders may affect the testator's mind or soundness, drugs, age, dementia. A rule that I have in the office, and is no law, it's just for me best practice. If you are over the age of 55, especially if you're not familiar to the office, I send you for a medical certificate. I prefer if the medical certificate is close to when you're coming to me. So I know some older persons will go to the clinic and it's hard sometimes to get a psychologist. Presently, you have a question? Presently, you can get your general practitioner that you're familiar with to do that mini mental test. I need to see it. And I usually give you a letter to accompany to the doctor, and you take that to them and they're aware of what they are required to do. They're going to do a test. It's usually out of 30. I see that, and then I move from there. I do not start drafting until I see it. I used to say 65, but dementia affects persons even earlier these days. All right, we have a question.
Hi, Kim. This is an online question. Good evening. If you have property outside of Barbados, can that be placed in a will drawn in Barbados?
Of course.
Of course.
Of course. I encourage you to do it. Yes, please.
I have a question with regard to B. Understand and recollect the claims of those whom by his will he is excluding, and understand that he's giving his property to one or more of the objects. Does that mean then that when you do that will, you should let whoever you are leaving property to know about it?
Absolutely not.
Okay. The other question would be, so those who expect that they might be included.
Well,
but
who
not really,
expecting? Tell me.
who
I,
knows?
I always tell persons, especially when they have children, you don't have to.
No?
No. If you want to, you do it. And I don't want to get technicality when the law change and stuff, so I'm just going to say to you, parents, I'm not encouraging you to not leave for your children. I'm just telling you you're not obligated to. But it would be great to pass on your legacy. You hear that word? Legacy. Generational wealth. Those types of things. And that's a deeper discussion. But just remember, you have the freedom to leave to whomever. And it would be great if your children can benefit from your hard work. Okay? That answers your question, I hope. Yes, please. And when they're talking about excluding, that's like if a husband comes in and he is well aware that he is not including his wife, you understand that those are his instructions to you. I don't draft those types of wills, but you should get them to sign off on their instructions. Okay? Because you don't want to draft a will that will fail or be problematic. Why would you? You know, you've wasted the person's time and money. Okay? So that is what they mean. You know you're excluding, and you know you're not leaving for certain persons. And it is of your own volition that you're doing it. Right? Yes, please, Brother David.
They say room in Barbados for oral will.
Go again.
A non-written will. They say room in Barbados for a recorded will.
Listen, I don't want to say off the bat, but I know that there's a dying declaration, and then there are times when, I think back in the war, that was more so when it occurred. But oral will, I'm wondering if we do videotaping here, I am not sure, and I don't want to ask you off the cuff, but I could send back the answer to you. But from my understanding, those dying declarations, I think, were for soldiers in war, you know, when they were on the battlefield and they're in a paper or anything to write with. I saw another hand.
Good night.
Hi, good night.
Concerning your previous statement about a husband leaving out the wife out of his will.
Yes, please.
If they're not together, they're still married. Let's say they've been separated for 15 years.
That's right.
Then why wouldn't you?
No
It
claim.
would still be a failed will?
No, because if the law provides that 5 years immediately before the death of the person and you've been separated, there will be no spousal claim.
Okay, thank you.
If you have been separated and there's proof that you've been separated in 5 years immediately before the death of the testator, there's no need for them to provide. Pardon? Common law unions are treated the same way as marriages. We identify common law unions under the Family Law Act and the Succession Act. So if you have been with someone for over 5 years, common law union. You know, you always hear the joke, you go 364 days and go on back home and come back. Yes. So common law unions are recognized in Barbados, and they are treated the same way, and they attract the same rights. Good? So a gift to a witness, and this is important, a gift to a witness is void, i.e. persons who benefit under the will cannot attest the will. What do you think so? Let me see who's thinking at this late hour. Talk to me. The person who is signing the will is also a beneficiary under the will, but this will invalidate the will. Exactly. It raises some suspicion. You're benefiting from the will, and then you're signing it too? Right. So it'll be void. Persons who benefit under the will cannot attest the will Otherwise, though the will is still valid, that person nor his spouse cannot take the gift. The gift will fail to them. Okay? So normally you will see attorneys or their legal secretaries will sign the will. Okay? And that exception there, for the purposes of this presentation, we can just read it quietly to our hearts. All right, so Brother David, I actually had the answer there at the bottom. Exceptions to formalities, sailors at sea and soldiers in actual military service, right? Other types of wills, we have living wills, holograph will. I've seen quite a few mutual wills, a husband and wife, where most of their assets are joint. And you will see something like this. This is the last will and testament of us, A, B, Y, and Z of Glenacre, St. Peter, Barbados. And we declare this is the mutual will of us both, made in pursuance of an agreement between us, that this will shall not be revoked by either of us individually during our respective lifetimes. So you can get mutual wills. A mutual will is revocable by one party during the lifetime of the two testators with notice. So they have to give notice. Yes, please, sir.
All right. Is there something called a living trust? You know, in the States, they do like a living trust. Is that applied here in Barbados?
Yes, please. What happened? I feel like you have deeper questions.
We had heard before that's not applicable in Barbados.
Can I talk to you before the streaming afterwards?
Yeah.
But persons do draft trusts. They do transfer their properties to trusts, and for various reasons, especially like if they have lots of land and there's a lot of beneficiaries. I've done quite a few trusts where the bounty is transferred wholly and solely over to a trust. And you understand then the trust will hold the property for the benefit of the beneficiaries under the will. So I've had clients come in and say, oh, I want a trust done, I want this living trust. It's very expensive. You could draft this will. Or you could transfer the property and hold with the intended person joint tenants if you want to. There are other ways around it. But yes, you can do trusts here in Barbados. All right? And I can leave it at that.
Right, so when you were talking to him after, you could include me, because I actually did have a question, because I understood that maybe it's better to have a trust done as opposed to a will. In terms of cost and the fact that after death, it is much easier to process all that you're leaving than waiting on a will. So if it has to be kind of offline, then include
Yeah,
me.
because I want nobody going to hold me to wait and say.
Right. So I just wanted
Because
to say
I have a lot to say about that.
That was
And
one of my questions.
I have
for
a
the night.
very strong opinion about that.
Right.
And I see the benefits. I am very honest with my clients. I will tell you these are the benefits. I will do the cost analysis for you. 9 out of 10 times, the person is going to come back and transfer it to the child by way of the deed of conveyance, hold it as a joint tenancy with their child, and when they pass away, because what they're doing is emptying their estate, because the probate process is long. Let everybody hear what I say. The probate process is long. It is tiring for us attorneys as well as you, the client. So that's why probates from 2019 ain't come back yet. You understand? So that holds up sales. It drains persons every day. What's going on? So a lot of persons are looking for alternative methods of estate planning. And a lot of very savvy, retired women are doing it. I'm not saying a lot of men, I'm just telling you in my practice. Kimberly, drain it. I got one child. I got one house. I got some shares. I selling them there tomorrow. Come, drain this, because you ain't putting me through that probate process and you're not putting my children through it. And that is why they would then seek other methods like trust. But then there are other things that they may not like when you're dealing with the trust. The cost to draft the trust. The cost to transfer it, because you got to pay property transfer tax. You got to pay that stamp duty. You got to pay the attorney. You understand? You go up here, man, Janet, man, what happened? I mean, what happened?
Sorry. It just blows my mind sometimes when you decide to do something and you hear, oh, you have to do X and Y, but yet there are some things that you can do, and like some people do it one way and other people do it the other way. And a case like that is like even like your title deeds, let's say, you can go, some places you can go and get your title deeds back. You can go and say, okay, I finished pay off for whatever, and the bank, you know, once you say, and they can
You get the release.
They get the release. Some people tell you, oh, you gotta go to a lawyer, let the lawyer do all the whatever.
Draft the
then,
release.
You know, so there's a cost, whereas it's free to just go and say, and then why can't you just have a document that you sign up, that when you finish your thing, you just sign and say, well, X, Y, Z, and sign it, and it's notarized by the lawyer or whatever to say that all this is done. So you find that I have a lot of things in place that very time consuming.
But can I ask you, the reason why you would need a lawyer to draft a release is, are you paying off early, or are you selling the property before the mortgage is finished? So when you're saying to me that there's an instant where you finish paying the mortgage, okay, and the attorney, then you have to get an attorney to draft the release? All right. Let's go. That they like to make work for us? Okay. All right. All right. Once a party has died without revoking the mutual will, the surviving party cannot, after the death of a deceased, revoke the will. And that's just because I find some married persons, they like to do mutual wills. So I wanted to give a little bit more on that, just in case you and your partner wanted to do a mutual will, you will understand what it is. Yes, please, yellow shirt. Ask her.
So it's best to do a gift instead?
Hey.
I just asked. Wait.
I ain't say that.
No. So like when people are alive, you could actually give the person like the property deeds.
You could do a deed of conveyance. I am not sure that I am fussy about deed of gift. Depends on how well it is drafted. You can do a deed of gift. I think Alex said in the last occasion, she wasn't fussy about it either. Neither am I. I could do a deed of conveyance. Some people say a deed of conveyance by way of a gift in exchange for natural love and affection.
Why asking that is, what is the difference in cost?
There isn't a difference. You still pay PTT. Yeah. You still have to pay the stamp duty on it.
Mm-hmm. Stamp duty is 5% or
1%.
1%
of the consideration. So if your property is valued at $80,000, just rough figure, and you're transferring $40,000, just half share, it's valued at $40,000. I still can work out stamp duty and PTT. Still can work out my fees. So you can as well do a deed of conveyance, which is a proper root of title.
Okay. Thank you.
No problem. I feel like you get all the questions that you wanted answered tonight. All right. Important. Appointment of executors and trustees. If none appointed, the will is still valid. Okay? But I think it's carelessness on a drafter to not appoint. Ensure that an executor is there. But there's a way you would deal with it. The testator should appoint a person who he considers trustworthy, of integrity, and more importantly, willing to serve, conscientious and organized. Why is this important? Why do you think this is important? Y'all know what's an executor? What's an executor? Person who will manage the estate. Person who will carry out your wishes. Sometimes the executor is also a beneficiary, right? And that's even more incentive for them to make sure the will is probated. Someone who is conscientious, trustworthy, and willing to serve. There are many times that an executor will be like, I didn't sign up for this. I do not have the money to front these costs. because it's a cost to advertise in the nation. It's a cost to pay the Gazette. It's a cost to do the running up and down. It's time consuming. We understand. So I normally would tell a testator, well, if it is a good friend of yours, just let them know. You know, I'm thinking about making you my executor or executrix if it's a female. Let them know, okay? And practicality, we would always say, choose someone a little younger than you. Practicality, but you can't really count on that these days, right?
Together. Sorry. Everybody start to get old together. So then by the time the wills and whatever, sometimes they're all dead.
Oh, Lord, not all dead.
Yes.
Well, in that case, where an executor has passed, you then go towards the order as prescribed under the non-contentious probate rules, England. So you will start with the residuary legatee, aka the person that is set to inherit the residuary. And then you come all the way down. I could give you the list if you ever want it. So you start with the residuary legatee. If it's a sole beneficiary, that person has the right to come forward. But there's a list in the event that the executor dies. So all is not lost if an executor dies. You then will have to provide the death certificate of the executor or executrix. And once you are a named beneficiary under the will, you have a right then to come forward. But there's an order of priority. It doesn't always work that way. But if you're a beneficiary, you have a right to come forward then. Okay?
So is it a good idea then to have 2 executors?
It
Yeah?
is. It
Yeah?
is. I like 2. Some people like 4.
Oh,
We could go up to. Yeah? Especially in dealing with land. There's no limit to the number of executors to be appointed, but generally it is thought that 2 executors are adequate. That's fine. Type of estate may dictate the type of executor appointed. Some persons would appoint an attorney, some persons would appoint a trust company, so it's up to you, all right? A minor can be appointed an executor but not a trustee, but cannot take probate until they turn 18 years. Would not advise you to do that. You wait, you either wait or another beneficiary can come forward. But as I said, and I didn't tell you all this, life is hard enough already. Why you can make a will harder for you? You understand? Oh, the girl don't laugh at me, I gotta laugh. Yes, please.
A lot of the younger lawyers now are more, let me choose my words carefully.
Yeah, because you say younger lawyers, I stand up. Because
Because y'all have a different way now of looking at it, a more progressive way. Because a lot of the, like say, mature lawyers and stuff, the kind of advice that you're giving here now,
Oh, there.
some of them would never have dispersed it or shared it or whatever, because there are things that you're saying here, I'm sure, would have been known way back then. But a lot of lawyers, or older lawyers, tended to keep a lot of stuff to themselves. I don't know, for whatever reason. So, and it affects like the way wills were written, how the older people write out wills and all that. So I'm just saying that you dispersing information that probably, if other people or older persons, like our parents and had that kind of knowledge, we probably wouldn't even got to be here. So I don't have this kind of discussion. We have discussion at a different level.
I take it on an individual level because I've learned a lot from older attorneys. There are some attorneys that will willingly give information. What I will say is that personally, my approach is always a very knowledgeable and intelligent client is my best client. So that means that the more you know and you understand the process, it leads to less acrimony between the attorney and the client, If you set your boundaries up front, you tell them this is what is going to happen, this is the impact of what you do, I find clients more so feel comfortable with you. If you say up front, that's not how I do things, this is the way. If you choose to do another way, that is on you. You let them go their way. Because it makes no sense having a client and you and the client are already at loggerheads because you're giving advice, they're not trusting you, they're not understanding the process because they're going to make your life very miserable. So for me, a very informed client, a comfortable client is my best client. And that's the approach that I always take. More you know, better for me. All right. Right. Same person may be appointed executor and trustee of will. Executor is where the person has only to collect the assets, and I'm showing the difference between an executor and a trustee. Pay debts and distribute the estate to the beneficiaries. A trustee is where there's an ongoing management of assets, so if you have a remainder interest or if there's rental property. So there are investments to be made, there have been directions for investments to be made, where, for example, where a property has to be held and managed for the benefit of a child, so that it's held on trust until that child attains the age of majority, then a trustee is appointed, okay? Both an executor and a trustee, they have wide statutory powers, which are similar in relation to the property of the testator, including power to maintain, dispose of, invest, insure the assets. So you understand how important an executor and a trustee would be. A trustee or executor is not to make a profit from his office. But the will could provide, there's always a, I tell you, I'll be living in gray today, but the will could provide for his or her remuneration. An attorney, a professional trustee, is only fair, they have a lot to do, right? Especially where a trust corporation or professional is appointed trustee. A trustee or executor is entitled to be reimbursed his expenses properly incurred. So I always tell clients when they're dealing with the will, the probate portion, please make sure you have very good accounting and records so that if we ever had to call you up for a statement of the account, you can provide that, right? So these are the things you're thinking about when you're coming to make a will. And if we go back to Bob, these are the things he has to also think about. Is the executor going to do these things? Are they going to be willing to go the extra mile, yeah? So you only are reimbursed. So let me give an example. The nation ads are just under $500. The fund may not have been left under the will, meaning a designated account to carry out these things before probate. So you have to pull your pocket. You need to be reimbursed. You're the first person aside from the attorney who is paid, okay? What can you dispose? Testator may dispose of real and personal property in his or her will to which she is entitled, beneficially entitled. These include interest in land or leasehold, money, shares in companies, business and partnership interests, property given to the testator in the will of another, monies from a life insurance policy where there is no named beneficiary and is usually just stated as the estate. Okay? All movable property, for example, jewelry, cars, furniture, anything like that. Property by which she is co-owner as a tenant in common. Cannot dispose of property that he does not own. Very important. So you wouldn't draft a will and the person does not own the property. The first thing when you are coming to someone to have a will drafted, I always tell you, please walk with your title documents or proof of ownership. When you're coming to draft a will, I need evidence of ownership. Just for comfort. Had a horrible situation where the lady had terminal cancer and she was rushing. And I'm not sure it was explained to her how she owned the property. We drafted the will. We told her, well, where are the title documents? I ain't sure. Just come out of the hospital. And you're not going to stress her. You know, she's mentally competent. She has her doctorate certificate. She wants to get it over with. Let me just, you know, I don't have long to live, Kim. I want to go to the queue in the community. Literally what she said. I want to go queue in the community, Kim. I want to go and sit down and clear my head. When she passed, however, she did not own the property singularly. She owned it jointly with her daughter. Rightfully so, Miss was upset. What do you do in that situation? I think gladly the other attorney understood the type of situation we were in, and we understood that that gift will fail. The rest of the will remain valid. So I always say there's that slip up, especially in circumstances where, you know, the person is not well, but always ask or always walk with your title documents, proof of ownership, okay? Types of gifts that may be left in a will, devices, and legacies. Personal property bequeathed is referred to as a legacy, and money as a pecuniary legacy, money legacies then. A gift of land is referred to as a device. Gifts can be specific or general. With a specific gift, it is identified. For example, I give my 2010 Toyota Corolla registration number MJ210 to A, B, or C. Or I give one of my motor car vehicles which I own at my death, because at the time you come to me, you might change your vehicle. So some people make it more general and say, you know, I give this car, like whatever I own at the time of death, to this person, okay? As I said, read with your heart. Secret trust, fully secret trust. I don't want to complicate this. We're doing straightforward wills here today, okay? A will may give a life interest, i.e., I give my house at Glenacre, St. Peter to AB for life and thereafter to YZ. Y'all understand what is a life interest? What is it? During your lifetime. You cannot sell or dispose of it during your lifetime. You maintain it. You keep it in good, tangible repair, good repair. Make sure that it is good for the person waiting to inherit it at the end, which is we call the remainder interest.
Your maintenance is
Yes.
required
Yes.
for to live in the house?
You should.
No, if I'm
What?
getting
Sorry.
to get what you want to.
You saying something, but I can't hear what you say. Or you don't want me to hear that part?
No, but if I'm given a living
A life interest.
life interest in the home to be given, to be passed on to somebody. Let's say that person is not my child, not my beneficiary. Somebody else gets it after I die.
The remainder interest.
Yes. And I am to maintain it. Who's going to make me?
Who's going to make you? Oh,
Maintain it.
well, I ain't going to make you, right? But I would say to you, the trustee remains. The trustee will ensure, the trustee should ensure, because remember, they have to transfer it. So they're going to ensure that it remains insured, it remains in good repair and in good order.
So they can do it.
Look, I don't like absolute answers. I'm going to say they should. But the life interest holder should also maintain the property to a certain extent, not adding value to it, but just maintain it that the person behind you can. But I would tell the trustee, you know, you're going to go and check on the remainder interest. Yeah?
You're not allowed, you can't allow to let overgrown things. You can't, you know, so there's still people, there's still supposedly checks and balances in place to kind of, you know.
Let's use a real life example. A testator will leave a life interest for his wife sometimes. Testatrix will leave a life interest for their husband. Okay? If the husband or wife, they have no issues with that and they're willing to remain in the house until they pass, and then after that we transfer it, I would think, I am living in a house. I am living in it every day, using it, benefiting from it. I can let it run down because I ain't got nowhere else to go. Suppose it was the house that you and the husband are living in forever and ever. You can let it drop down on you? Nah, big man, try and take care of the house. Those are things that I don't think I should have to tell you as a life interest holder. However, we are true. Checks and balances. Remember, when we spoke about the trustee from further up, the trustee remains involved if there's maintenance required. But if there's no fund to pull the money from, what you're going to do? What are you going to do? The trustee said, well, I have the money to repair, and these are real things. And I could understand the question, but I also look at it practically. When you finish, the remainder man has to benefit. I think at minimum, you should maintain the property. Okay? Listen, I keep calling you Jackie. Okay. So, a life interest operates immediately upon the death of the testator. There are no legal documents required. It is understood that they have this life interest. Okay? I wanted to say something, but I'm not going to say it when we're streaming about that life interest. All right. Limits to testator's freedom. And we touched on a couple of these things before. A testator is generally free to dispose of his or her assets. So remember, we were dealing with Bob. So if you see masculine, you know why. That he may decide except where he or she has a spouse or child, right? Under the age of 18, of course. If a testator dies leaving a spouse and a child who is a minor or who is incapable of maintaining himself or herself because of some mental or physical disability, the spouse has a right to 1/4 of the estate, section 93, subsection 1 of the Succession Act. You have a question? Mm-hmm.
The testator dies, leaving a spouse and a child. I know of a situation where, and I've always been curious about this, the testator or the owner, the two owners of the house, they had a child. But they died, they died and the child was still a minor. Well, no, let me backtrack a bit. The persons who bought the house, they had a child.
Right.
The wife died. The husband remarried. And then he died, leaving a minor child and a new wife.
He had a will?
No.
So, the law of intestacy will step in.
Okay.
Okay? So, if we go down, I thought I had it up. Hold on. I want to give you the exact section. Hold on. I pulled down the app before I came in here. I can read it for you. Oh, okay, here. I'm going to read it for you. Give me 1 second. Good. Distribution on intestacy, section 49, subsection 1 of the Succession Act of Barbados, cap 249. If an intestate dies leaving a spouse and no issue or next of kin, the spouse will take the whole estate. Now, when we say issue, we mean children, okay? If an intestate dies leaving a spouse and no issue but next of kin, the spouse shall take 2/3 of the estate and the remainder shall be distributed in equal shares among the next of kin. So, you know, next can be like mommy, dad, that type of thing, right? Subject to subsection 4, if an intestate dies leaving a spouse and one child, in that situation you're seeing, the spouse shall take 2/3 of the estate and the remainder shall go to the child. A spouse and children, the spouse shall take 1/3 of the estate and the remainder distributed among the children in equal shares. I'd like to quote that specifically. That is section 49. So, stepmommy, child, she's going to take 2/3, remainder to the child, which is the 1/3. If he is a minor, he or she is a minor, it will be held on trust by the child's mom. If you said the mom died, it will have to then be hopefully next of kin or her to hold it on trust. Whoever applies for the letters of administration, stepmother will have to then hold it.
Does it matter if the house was bought by his mother?
No, please.
No? Okay.
Matrimonial interests cease.
Would think that. Okay.
So you're asking me, suppose they built the house before stepmother came in. She became the wife. I was going to sing a song and, sorry. So stepmother steps in. She's the spouse at the time of death. So she's subject also to those rules. I know, I understand. I could feel what you're probably thinking, but that is the thing when you get married. You got to think about marriage. Marriage is, love is 5%. You understand me? Love is 5%. When you start to acquire and enter into contracts with your husband, it becomes a business decision every place, every moment. Nobody don't like me to say that, but I'm saying it to you. So you enter into a mortgage with your husband, that's a business decision. So when you remarry, you understand that whatever plans you had before are on pause because you now have to factor in the spouse that is protected under the Succession Act. All right? But get married, have children, okay? All right, so where are we? Jackie, I don't know if I want you out here to the front no more. Because you Jackie, you hilarious, girl. Because you say everything I probably be thinking. All right, we are to limits to, right, okay. Any questions on that? Are we good? All right. I want someone to read that part loudly for me. The spouse's legal right takes priority. Okay? Good. So when drafting a will, we always ask if you are married, cohabitating. What is your marital status? Okay? The spouse has right to make election between any gift made in the will and his or her entitlement within 6 months of probate. The executor must notify the spouse of the right. Good. The spouse who was legally separated or not cohabitating for 5 years, or say for instance that spouse killed the person, you're guilty of an offense against the deceased or child of the deceased, punishable by imprisonment for 2 years or more, is precluded from taking a share as of right. Okay? Any disposition made by the testator within 3 years of death with the aim of defeating the spouse's right or the child's right may be set aside by the court, and the asset will form part of the estate of the deceased. Y'all understand that? You get it? All right. Testator must make proper provision for a minor child or a child incapable of maintaining himself or herself by reason of mental or physical disability, and we touched on that. The act does not provide for a specific percentage, but can apply to the court to make an order. Yes, please.
Pardon?
Wait, no. Yes, yes, yes. You can put those types of provisions. What she's asking about, if, for instance, your child is a minor, you can make provisions for guardianship in the will. Okay? Yeah. No. Is this to defeat the father's rights? Give her the mic. Because this might be territory that we're going to talk about offline.
As a single parent,
Yes.
father
Never
used to
took
bear.
part.
I would not want that somebody came who had nothing to do with my
Go
child.
up a little higher.
Sorry. No, I was saying I would not want some person who had nothing to do with a child all of its life to appear after I have died and offset my whole child. So that was why I was asking whether
You put
that
it in
can
your
be
will.
contested
That's
or
right.
not. Okay.
Put it in the will.
Amen. Thank you.
I think that is under the Family Law Act, subject to correction. Any other? Okay. I swear I saw you got a shirt. Oh.
I have a question concerning the underage child.
Yes, please.
So suppose it's husband and wife. The husband has a child that is not from the wife, that is underage, and he dies. The divide before you said was 2/3 to the wife and 1/3 to the child that was underage. Is that the same thing of a child outside of the marriage?
But you said that the child was not the lady's child.
Yes, but it's the husband's own.
So the child has a mom.
But you're saying to claim for his property, his estate, his portion.
But he's a minor
Yeah.
with parents.
One parent, because the other one died. The deceased is his father.
The deceased is his, no, I'm not mistaken. I swear you said the child died.
No, no, no,
Oh,
no. The
sorry.
father died.
Sorry.
A husband and a wife. The husband has an outside child.
Right.
The husband dies.
It will
What is
extend
that
to the
child entitled
the
to
same-
a third
the same.
of
Once
the
the,
property
yes.
that the wife and the husband.
once the father's name is on the birth certificate,
That was not you.
the child is entitled similarly to a child that was birthed between the two parties.
And
Well, then let me finish. So say for instance, the child's name, the father's name is not on the birth certificate and there's some contesting of whether there's paternity issues.
Yeah.
If there are no paternity issues and it is understood that this is the gentleman's child, then he's entitled as under the intestacy.
okay.
Ask me what you really want to ask me.
No, I asked. That's why.
Because I
wanted
want to
know.
answer you properly.
No, that's why I wanted to know what would be if the child would be entitled to his
His share,
share
yes
of the-
please.
Okay.
Oh, Lord. But I hope you understand where I'm coming from. Once it is the child of the deceased, they will take. I didn't say that, ma'am. I said, I gave a caveat to that. I said if there are no paternity issues, because then the child will have to engage in a paternity suit and have a declaration from the court. Because especially if you don't have, if the father's name is not on the child's birth certificate, then there's a question of paternity. But in the wife child, I think what you're saying to me is, and let me see if I understand it correctly. Mom and dad together, husband and wife. The husband dies. Dad had a child outside of the marriage. After, so, right. So the child is still the whole blood child of the father and will still be will still be entitled as under the rules of intestacy under the Act. The caveat is if there's a question of paternity, this is the wife now dealing with the estate. Wife understands this child exists. Wife knows that the father's name is not on the birth certificate. What do you think can happen? A paternity suit can happen. Paternity suit is going to happen. And if successful, that child can then rightfully claim under the Succession Act. Yes, please. It's a very loaded question. And I hope it's still a court application. Paternity suits are not always successful. So it's at the discretion of the court to change the birth certificate to have the deceased name inserted on that birth certificate. Right? And she's not talking about situations that don't happen, you know. These situations are happening more regular than you think. Yeah? Yes, please.
I have an online question.
Yes, please.
Parents died, left no will, house and land. 4 children, 1 child lives in the house and behaves as if it belongs to them. Brings in one of their children to live there as well, without speaking with the other siblings. Have also sold items from the house. The question is, what can the other siblings do legally?
Get an attorney immediately. And all 3 of them should go together.
Okay, nothing has been done yet regarding letters of administration, etc.
They need an attorney immediately because you need an attorney to enforce your rights. Yeah?
Okay. Thank you.
Yeah, no problem. But advice and the underpinning advice is all 3 of them band together and go, because you'll have the majority of the beneficiaries who are making the decisions to the exclusion of that one so that they can make a collective decision. Yeah? That's unfortunate. See why it is important to have a will?
Parents before they died. The 3 probably got their own home and all of that already. So, you know, somebody might just be digging in the heels to say, well, part of this belongs to us too. It don't matter. So I'm just saying it could be a situation like that. And does that one person who is living in the house have any, that take care of the parents right till death, have any rights to say, well, look, you know, maybe more than, it can be an even split then. I'm just asking.
I know. Then give me your bill. Let me, oh wait, go ahead. Right.
I have a question.
Right. Let me respond to this. There are many ways I could respond, but this is the one I'm going to give you because we're streaming. In that instant, I would say, well, give me your bill for caretaking. Let's pay you. Because you don't have you're not more entitled than the other children. Maybe you were the one that was practically here and could then take care of it. Then what did we contribute? We didn't do anything. We didn't give any money. All right, well, tell us what your bill was for the last 10 years, and we'll take it out the estate. But you cannot then appoint yourself as the majority beneficiary because you did that. There's a thing called goodness will come to you when you do good. Go your way and serve the Lord. Right?
Mm-hmm. My question is, say a will was drawn up, and a will was drawn up, and you have say, there's an aunt, and you drew up a will, and you left, say, your house that should be divided between the 3 remaining, your 3 nieces or whatever, but one niece is in the house, right? and the other 2 are not in the house. So I'm thinking, so I mean, the will says that that's how it should have happened, right? That's how it should happen. In other words, I live in this house, and the 3 of them are supposed to benefit from the house. In
Right.
other words, either all of them live in the house, or to sell the house and divide the money or whatever. But one person remains in the house, and the other 2 are not in the house.
By choice?
Well, by choice to some extent.
Right.
But I'm saying, if you decide that you want to remain in the house, shouldn't it be then that you pay out
Of course.
the
other 2?
the other 2 or whatever?
Yes. That is going to be on the table immediately.
Exactly. But I mean, there are some people who decide, well, this is it. I was the one that was here all the time. I was the one that was still living with the aunt.
But that's your choice.
Exactly.
You decide that, listen, you decide that you're going to take care of your parents. You decide that you're going to stay there for the benefit of the person ailing. Okay, that's your choice. I usually say, okay, do you want to be reimbursed? Okay, you say no, you want the house. Okay, we could take an agreement that we won't sell you at the open market value. We would sell you at a reduced cost minus what you would have been paid had you been paid for your services over the years. Those are business decisions that not necessarily legislated by law. So we would sit and I like to have around the table discussion, and I tell all the beneficiaries, come in, let's make a decision. And then we will sign the deed of arrangements or whatever you want to call it. If you're going to say, look, I'll give my interest to them because she really was there and she deserved it to me, but I can take my other gifts as under the will. Yeah? That's more so a decision that the beneficiaries will have to make. Yeah? Any other? Yes, please. Yes, stop.
All right. I'm not sure if this is the right place to ask this question.
Well, be here.
No, I mean, anyway, I have given one child, one child has taken from me what they think was their share of the property. So
Taken?
they now own the house.
Taken?
Yes, taken, negotiate, whatever, I don't know. So the other 2 children, now how do we deal with them in terms of what is left?
Well, that's a decision for you. Because you said you have negotiated with one child.
One child.
Okay.
I've given that child whatever the property is before I die. I ain't dead yet. I'm still here.
So you transfer the property to a child.
Yes.
So you would then have to say to the attorney, okay, I have this left, and this is what I want to give them, and you could preclude them from, not exclude them from the remainder of the will because you've already given them their portion.
No, you haven't dealt with the others. You only deal with one.
But that's on you. You're not going to come in and make a will to deal with the 2 of them.
So suppose they thought that they were getting...
What thought make a man do? You could think a lot. You don't know what your mother or father or your parents can do with their property, and they're not entitled to tell you. So if they thought that they would just get shot, they put money in the property,
Well, no.
they help you pay the
No.
mortgage? Right.
No.
So, okay.
There were little people.
Little people, all right.
So it's only now what is left now will be...
Whatever is left. If you got a donkey cart and a gun, anything. You do what you want to do with your property.
Yes.
I just tell you to be fair. If it makes business sense for you to change it now to give a child, you do that. But you will have to understand the other children may feel a bit slighted, up to them. But you give them whatever else is remaining. You don't have to give them part of it.
Okay. All right.
Ask me what else you want to ask, don't you?
No, that's what
that's
I
what you
wanted
wanted
to
to ask.
ask. Because I'm thinking of it I know that already there is some contention.
Right, and you're going to make it worse by transferring to one child.
One, yes.
Right. That's freedom. I think what the attorney can do is give you options. They can't tell you what to do because you give it the instructions. So I would say, well, do you have other children? And you are okay with precluding them from enjoying this interest.
Okay. All right.
Yes, please.
All right, so we have another question, Kim. Single person leaving house and land, but they want to leave the house to a non-biological person, so not the kids or anything like that, who took care of them. Are there legal challenges that the biological children can make to prevent a non-biological person from?
So just let me repeat this so I understand.
Single person.
There's a single person who has children already.
Has children.
And the children, however,
Are not.
going to benefit from a property or a gift.
Yeah. Is being gifted to, let's say, a
Another
friend.
person.
Yeah.
Right. So the children could say, well, it's weird that mommy ain't give us anything. I can contest the will. Because it sounds as if she was influenced unduly to do that. They could bring that argument and they would have to go to court. And the court would then have to make a decision as to whether or not the will was procured through nefarious means or means that would excite the suspicion of the court. That's what we like to say.
So if the caretaker can prove that the children
Is the caretaker?
were not involved in the life of the individual while they're
Yeah, that's
understand?
that's a funny one, and it's going to look very funny on the caretaker because that person is around the person all the time, and you might get the argument that the testator was isolated from their family. You know, that is such a funny thing. That's why caretakers, to me, have to be very careful. It could be very genuine, and the person loved them, they were with them through the roughest times, and they decide that they want to give them a gift. A child could be very upset about it, and you can't stop them from wanting to ask questions. But the child will have to prove that at the time that the will was made, there was an undue influence, that the person being very vulnerable was forced to dispose of their assets. And you look at other things. Was there a previous will that had totally different beneficiaries? You look at a lot of things, so it's not a straightforward answer. But I would say it's not that there won't be legal challenges. There can be, because the children will be upset, of course, especially if you gain the most from a will of their mother, you know.
I want to ask two questions.
Yes,
I don't
please.
know
Of
if
course.
you will come to it. If you will, I leave it until then. If someone leaves you as an executor and you don't know, can you refuse to do it? That's one.
Yes.
The second one, if someone is left as an executor and refuses to carry out the wishes of the person who died, of
Yeah.
the will, how long or what can the family members or whatever do about it? I don't know if you do it, but...
No, that's excellent questions. An executor can refuse to act. They can absolutely refuse to act. And therefore, you will have to remove them. So the relief is the same. You cite them, you draft the caveat, you submit it to the court. There's also something called the executor's year, where you have to allow the executor a whole year to do what they need to do. They may do anything, we wait the year, and then we bring the action. So you can remove them by an order of the court because they have refused to act, right? I don't want to say, let me leave it there. Let me leave it there. Because let me leave it there. You can remove them, you can cite them, try to force them to act, or they could actually openly say, nah, I ain't about it, I'm not doing it. I am no longer interested in doing it. Yeah. Who would do it? The beneficiaries under the will would then come forward.
But I don't know that I'm a beneficiary.
Pardon?
So suppose I didn't know that I was a beneficiary.
So what I normally do is when a testator passes, I do a will reading. So you become aware of whether or not you're entitled under the will.
But all the wills I know is that I'll wait till I've gone down already and then people will turn up to see.
Well, yes, no, they're coming to see what they get. But
Yes, I know people don't know what they're getting yet.
no, but they're not to know. They can know that a will exists, but they don't have to know the contents of the will. So you will know, okay, this will exists. I've told my children. They know where it is. It is lodged more than likely in the will depository in the registry. Safekeeping.
So, when or how do I know that I should go and check to see what kind of will and what kind of
That's
whatever
right.
and whatever?
Good
And
question.
if I'm the executor,
You should know.
I should know, yeah.
That's why I said earlier, you could tell the executor. You should have a discussion with them. Well, you know, I'm trying to plan my estate and I want to make you the executor, executrix. Are you willing to do it? Have that open conversation so that there are no surprises
So
from
Anna,
before.
can have that conversation with you now?
Have the conversation. The other thing that you mentioned is how will you know? Normally, we would open the will, you call the beneficiaries in, and they'll be like, well, I know the lawyer called me. It's not obligated, but to me, it makes life easier. I call you up
yes.
and say, you have a number, you ask the children, well, they see this name in the will, do you know this person? Well, let them know we having a will reading. Everybody gets a copy if you want to be that generous. Or what normally happens is when someone dies, the clerk does a search in the registry. So that search is done for a previous application if it is a very protracted matter, or they do a search in the will depository to say whether or not a will exists. If a will exists, the will is then removed and you get a certified copy, and that is when you start to act then. You say, well, call in this beneficiary, this person is named, you can't find them, you send a letter. Say, well, I have this will, you are a named beneficiary, and let them come in.
So then it's the lawyer who doing all of this, not the executor?
Well, the lawyer helps the executor. That's how you do checks and balances. You can't let the executor go on a product of their own. The lawyer facilitates the legal process. They draft all the documents. They do everything. They call the executor in. All right, you need to bring in $700 for the retainer. This is for the ads in the paper. This is for the ads in the official gazette. This is for the clerk who doing the searches. So all these things are done.
So you're the person advising the executor.
That's right, because
they are.
That's right. That's right.
Don't call me.
What is the case where the grandmother or grandfather got the will in a little box underneath the bed?
Still
never
valid.
deposited.
Still valid. Still valid.
So how will one know to get it read?
So normally when someone dies, you would tell them, well, did they have a will? I know. Well, let me check the will depository. Go and dig up in the person's belongings, because you know we have those older persons that never say anything. So we had an instance where a lady came 40 years later, she found a valid will. Letters of administration done taken out. Property done distribute. Hurtful, right? And she was the sole beneficiary under that will. But, unnecessary money? But if she now found the will, because she said her brother gave her the documents just before he died. She never looked through them. And there lay a valid will executed by her brother and 2 witnesses. What do you do? So I always say go and search up. You know, the person used to keep the title deeds this place. They used to keep the documents. That's why I ask persons, have you told your family that you've done a will? No, ain't their business. But then how do they know? How do they know? You have to let them know at least, well, I draft this will, I went to the lawyer and I draft this will. If something should happen to me, look, A, B, C. The executor already knows what they're supposed to do. Or if you're that type of lawyer that real familiar, you know, down to earth, you could say, wait, my client died, let me call the family. Because I know that I drafted a will for that person. I don't know if I'm the last valid will, but I know I did a will during their lifetime. Yeah? Yes. Jackie, I know, you know. Well, you come.
Okay. No, I was asking, like, you can have, like, say people who had no children at all, no children. They had a will, they died.
Pay closer to
They had a will, and everybody died, even the last person who was the last to benefit from the will. But then, what comes into play there?
the estates of the deceased.
Not only externally deceased, because they may not have had children, but then the lawyer will tell you, well, they may not have had children, but they have nieces and nephews.
That's
and
right.
all those persons then have to be notified and be made aware. And
That's right.
They got to get letters to say, well, the person is dead, and and authorize, give affidavits and all that.
They give consent.
To consent for whoever else know to act as the
administrator with the will and next.
or whatever. So I'm just saying that, you know, that is something too that you have to consider, because I mean, a lot of people may not realize that
That's right.
nieces and nephews and those persons who are never
Will be entitled to share.
entitled, and you might have been the one out there
That's
doing
right.
everything all the time, and all of a sudden you realize, oh shoot, well, they got more people that are more important than me right now.
But remember what I said previously. Update your will. Update your will.
But unfortunately, when it comes to the updating part, as I said to you, we have people who would have made wills a long time ago. They may,
Yeah.
yes, update, but then when they get to a part where they have dementia and stuff
Dementia.
like that, they're not in a position to do any updating. So whatever will they, whatever
have to
last
leave
will
it.
is has to be left, and that's what is.
That's
the-
right. That's right.
That's what is. The
You,
one
you know, we could plan and plan, but we can't plan for every eventuality. So you try to do your best with what you have at the time when you're drafting the will, because you could do your best to draft and most of the beneficiaries pass. And if you haven't gotten a chance to update it, it's best to leave it, let it go to the heads of administration with the will and nets. Yes, please.
Yeah. So suppose you had a will and it was not registered at the court.
Deposited.
Yeah. Is it still valid?
Of course.
Okay.
Of course. The depository is like safekeeping. We like to put it in there because you don't have to think about where it is, but the court could lose your will too. But I've never had that instant. They're awesome. But you could draft a will, leave it in your house, but just make sure that somebody knows that the will is there. You could give copies to whomever. You can have it in a safety deposit box. But once you draft that will, and remember I said there were 3 things that you need: mental capacity over the age of 18, and attested, the witnesses have signed it the proper way. Those are 3 things. There's no requirement for it to be in the will depository in the court. Yeah? Okay.
You have another question?
Oh, sorry. Yes, please. I just want to say that the time in the time limit, right? But we can try and see if we could power through with this. Here we are on slide 19.
I don't have house and land. Right?
Okay.
I want to know if I can still do a will.
Of course.
Right? Because why I ask you that question, my son tell me, Mommy, try and make a will. So I want to know what I have to do.
Same thing as if you had house and land. It does not matter. Whatever you own in this world, you put in your will. If it is a page long, a paragraph, it is your will.
A follow-up question to that. On the issue of money in bank accounts, if persons are not signatories, how is that procedure done if the will leaves money in these accounts for these persons, but these persons are not signatories or so on? How is that?
But the accounts are listed in the will?
The accounts are listed in the will.
Right. So what we normally do is we write to the banks and we confirm that the person has passed. We enclose a certified copy of the death certificate, and we ask them for what the balance is in their name or if there are any loans in their name. And the bank will normally respond pretty quickly and let you know, because you have to create your affidavit of value. So you're going to need that information regardless. So once the bank responds, then that money will be considered in the estate, because that also is how you calculate fees and stuff.
All
So
right,
you're
go into a
renting
question
rights.
there now, but here's another question.
Yes, please.
A person is a joint account holder with a person. The individual dies, and that person is using that account.
That's fine. That will not
to-
form part of the estate.
Repeat again.
That will not form part of the estate because it's a joint account.
So once it's a joint account, it is not part of the estate.
No.
Even if the person meant to list it. So there are other children involved. So one child is a signatory to this account.
Difference between a signatory and a joint account holder. So you're a signatory for the purpose of a power of attorney or something.
I think they just set it up that way.
So it's set up as a joint account. Let's say it's a joint account for now.
All right, let's say it's a joint account.
Then that will not form part of the person's estate. That will then go to the joint holder, the surviving joint holder.
Surviving joint holder. All right, so we see some follow-up questions, so let's do them.
So even if it's a joint account, but the joint account is John Brown and Peter Marsh, and John Brown dies, but that joint account requires like both signatories, that joint account cannot be part of the person's estate. So how does, given that it required two signatories and one died, and it's not either or, how does that work?
Well, I can't speak for the bank, but I know my experience with joint accounts. You submit the death certificate, and the bank then processes it as a single account holder.
My question is relating to what you said about getting the balance from the bank
Yes, please.
and you knowing how much money the person had.
Yes, please.
If that balance changes because somebody has an ATM card to that account,
How I know that you were going to ask me that, you know? Tell me about it.
what happens?
Start from the top.
You attain the balances from the bank.
That's right. I have written to the bank.
Yes, you've officially, the lawyer has gotten the balances for the estate saying how much money is on the bank account.
So where the bank moving it, where the bank allowing the money to be moved?
So the accounts will be frozen?
Accounts must be frozen. Those are
Okay.
my instructions in my letter.
Oh, okay. So if the bank fails to freeze the accounts,
We can have fun.
And somebody withdraws some of the money because they have an ATM card,
That's right.
then it's the bank's responsibility to replenish that account.
And the bank pocket deep.
Thank you.
If I have written to the bank and I have told the bank the person has died and you still allowing money to be moved, come on, let's have some fun.
So just for clarity, Kim,
Yes, please.
persons who have ATM cards to accounts of individuals who died, is it a case that, and especially if there are other siblings, does that need to be declared? How does that factor into this whole idea of wills and what is legal? Because you know, in a small society, you often hear stories of persons
Yes.
who had money on the account, person has died, and the person has access, and these monies go. So how do you address that?
Practically, my letter might go after the person swiping the card. Because if the person dies, you know, John Brown done gone to the bank. So then that will affect your interest. That will affect what you get. Because if you can't replace it, I can hold you to that. So you have taken let's say $50,000. Well, that's $50,000 from your share that you would have gotten. Or I'm going to put you in court. Yeah? I want people to understand how serious it is. I mean, we're laughing and joking now, but these are things that happen. You understand? And I can say this to people. Money coming into an account of a deceased person is now part of the estate and it should not be touched. A car, do not touch. House, do not touch it. The only person who has power to deal with an estate is the administrator, the purported administrator, and they cannot deal with it until they get the grant from the court, because an administrator gets their power from that grant. An executor gets power from the will, so they can handle certain things before a grant is issued. And an executor is held to a high threshold of care. And the attorney, that's why the question that asks is important. The attorney facilitates that. So if you go to an attorney and you say to them, I have this will, but I see somebody driving a car. I see somebody going to the bank still. Money is moving because I'm going to ask you to bring in the statements as at the time of death. And if money moves after that, then that's a whole different ballgame. The account should be frozen immediately, and the person who takes it, we will deal with them differently. I do not play with people's money or estates. It is a certain place for you when you do that. The only thing you can get before a grant is the funeral expenses. You can take the invoice to the bank, and the bank is going to issue that check directly to whom? The funeral home. After that, you are not to touch that money. And that's a serious thing. Leave people money alone. Leave people houses and land alone. You're not entitled to it. I don't care if you take care of them for 10 years. It is dirty business when you do it. All right? So good question. Yes, please.
Question for you.
Yes, please.
You know, just in the event that something happens to you and you put your children or one of your children on your bank account, so that if anything happens, you know, things
Have access
can
to it.
continue. That is fine.
That's right.
And you can put in your will that they have. How would that work? Because
you're putting them on as a signatory. Because I don't want muddle any bank business. When I always hear that you put your child onto the account, that
Just in
becomes a
case.
joint account.
Okay.
Right?
Right.
And that child then will benefit when you pass.
Okay.
If you have a power of attorney, however, and you say the person will have access, remember, once you pass, that power of attorney dies with you.
Right.
If you become mentally incapacitated before you pass, power of attorney cease. That power, because remember, you have to confirm the actions of the grantee. Remember. So are the, let me say, duly appointed attorney. So if, for instance, after you, God forbid, develop dementia, power of attorney is finished. Yeah? Any other questions? All right. I don't even know where we are. Where we were. Listen, y'all are bare action though. I like this. Right. I think we were talking about if any aim to defeat the spouse's right prior to death. And we will know that that is asset, hiding assets from a spouse or transferring it to a child. Okay. Revocation of a will. A subsequent will revokes a former will. Who knows that first sentence that you always see in the will? This is the last will and testament, and it revokes any previous testamentary dispositions made by me. Important. Read the next sentence, speaks. Marriage, unless the will is stated to have been in contemplation of marriage. All right. Divorce does not revoke a will per se, but will revoke a gift to a former spouse. So if you have a will and you pass after you have divorced the person and there is a gift to that spouse at the time, that gift will fail. Okay? Question? Oh, I thought Lisa had a question. Okay. All right. What's that, Jackie? We were telling me?
This marriage thing, it seems as though this marriage thing now, it says that you gotta get a lawyer quick before you decide to take that step. I mean, before you used to think it was just the priest and, you know, you decided you get married and you're going to get some counseling from the priest, but now the priest got to bring some other things to the table so that you are aware of what you're getting into, because you're making right now it sounds like you're making a business decision here. Right, that's what I'm saying. So I'm saying that if you're making a business decision, you got to bring the people who dealing with business into this discussion. That's what it's seeming like. I'm just saying that's my observation. So marriage counseling now have to also determine priest, lawyer, etc., etc. I get a bit scared here now. Because especially ones who come in to get married and they reach a certain stage in terms of life. So of course these are the ones that they get, getting married in the 60s and that kind of thing, So a lot of things.
I think what it is telling you is that gone are the days that a spouse is ignorant to certain things, because there are many women and men who sign things and don't know what they're signing because they trust their spouse. And when it comes then to property settlement, that is when you realize, oh wait, he only put the land in his name. Oh wait, the land only belonged to him? Jackie, you don't go wait till the end, because we have Miss Contentious there standing. You found a man with property. That's no problem. That's no problem. You're still entitled to a portion of it. So you're married to somebody for 50 years, 13 years, 7 years, and they had all these things before. You are still entitled to a portion. What would determine is the percentage which you're entitled. Of course, you have to negotiate. Well, that they don't know. Jackie, listen. I know there are bad situations. It is serious and it happens often. But we're going to hope that everyone in here is understanding what they need to do. I told you that love is 5%, and everything else added onto that becomes business decisions. And I can tell you this, I don't disclose person, but when I was getting married, my husband had his own attorney. Okay? And that is important. Because you need, me being a lawyer, I come in from a different space. And my husband will tell anybody, I have my own attorney, and he should. All right? Yes, please.
That last paragraph there.
Which paragraph, ma'am?
If the divorce does not revoke, but
the gift will fail.
Who will get the gift then?
It will go to the residuary.
And why would it?
Because you've divorced the man, you should not benefit.
He divorced me, it made a difference. But so if the will has not been changed and a gift is assigned to me,
and it was at the time, the condition was that the person was the spouse.
But if he still wants me to have it.
No, he does not. He does not want you to have it.
If he did not, he would have changed his will.
So let me give you an example. I have one ongoing probate matter. And in the man's will, he could not change it because he had terminal cancer. Mine was going. We couldn't get permission to go into the hospital, okay? So the will that he had was from 1998. At that time, he died 2021. At that time, he was married. He didn't get to change it. He divorced the woman around that same time. He did. So at the time of death, he did not have a spouse. So the gift was to my spouse, Patrice Jones. She's no longer a spouse. So it will now devolve to his residuary.
So if he did not say my spouse, but only call her name.
No, ma'am. No, ma'am. No, ma'am, she was in the will by virtue of her being a spouse.
But you can give gifts to anybody.
Listen, the man divorced you, he does not want you to get his house.
He should have changed his will.
He should have. The gift will fail. All right, I think we have 10 minutes. Look at your time. So so we revoke revocation, setting aside a will. Of course, we mentioned it, lack of testamentary capacity. Invalidity, it does not comply with the formalities required by law. It makes no provision for spouse or child, and I should qualify that by saying under the age of 18 or with a disability. Undue influence exerted on the testator, we spoke about that. It could be actual or presumed. Now, we ain't going into the technicalities, but you see it can be set aside because of that. Lapse of gift. Generally, a gift to a donee takes effect only if the donee is alive at the time of the death of the testator. If donee predeceases testator, the gift is said to lapse. A gift to a corporate body that no longer exists will lapse. Exceptions to the lapse include where the will provides otherwise, statute provides otherwise, and for example, section 83, the gift not to lapse where the donee is child of the testator, in which case the gift goes to the child of the donee. Okay? And here we are at question time. We made it. We made it. And I talked to y'all about half the things I wanted to talk to y'all about, but we made it. Any questions?
Can you explain jointly and severally?
In what context? Oh, joint tenants in common. Okay, when I'm doing this, I like to draw. So let's just imagine we have two boxes. Let's have a rectangle. So if you hold it jointly, when you pass, Mr. Rectangle over here passes, it goes automatically to the joint owner. If it is held, so it can't be, don't let me use several. Let me just use joint tenants and tenants in common. Don't let me complicate this. Joint tenants by, how do I not say this by just a crescendo? By survivorship. You are the last surviving husband and wife. That's right. So the husband passes, it goes automatically to the wife. Wait, boy.
Kim?
Yeah. All right.
Kim?
Yes, please.
Explain what was told me sometime that dead men pay taxes.
So if you pass and you still owe statutory taxes, remember there's an order of priority for debts to be paid. First one. Actually, the first one is testamentary expenses. Funeral expenses. And then, of course, if you owe NIS, land taxes, those things become liabilities, secured creditors. So there's an order of priority how you pay those debts. So dead men do pay taxes. They still owing, that's why you can't get estate clearance. So if you still owe NIS, if you still owe VAT, if you still owe land taxes, and you still owe your mortgage, or anything relevant to that property, yes, you still have to pay. So tenants in common, siblings, right? I didn't explain because I think she got her answer and she was done with me. Tenants in common is a little different to joint tenants. So tenants in common is, let me explain before getting too legal. If I own a property with you and we're siblings, you can devise your portion to your family and I can devise it to my family. Joint tenant, however, if you and I hold it jointly, you pass, it goes to me automatically.
Which is
Yeah.
more advisable if you wanted to make a change to the will, to do what I think they used to call it a codicil?
Right, the codicil.
Or to make a new one. Which one is cheaper?
Wait, boy, wait. No. Sister Bunike. That's what I mean on the spot. It depends on what you want to achieve. It's not a matter, and I will always say you pay for what you get. So if you want your will done and you want to change it and you want to review your will, do the will fresh and just make the amendment. There are attorneys that will say, look, it wasn't much. I'll charge you a little $250 here. Not much. I'm not telling you that is the going rate. If you want to do a codicil and your instructions are, I want to do a codicil, and the attorney has advised you of the costs, give you a comparison, then you do what you need to do. I don't personally do them. I do the will, and I charge you based on what you had to do. Yeah?
Julian?
Hi. Pardon?
Must the will be probated?
Pardon me?
Probated. A will.
Yeah. Yes, you have to probate the will.
Okay.
You want to know the process quickly? I could give you it in 5 seconds. So you get the will, you go to the attorney, will is read, beneficiaries are made aware. You do your searches to make sure that is the last will. You then advertise in the newspaper. You see those ads, the statutory notices, and one is done, we usually do it Thursday. It is done in the official gazette, must run concurrently. We wait 14 days. By that time, the attorney is drafting and gathering all information. I take longer than 14 days. That's all right, because I want to make sure that I have everything, that I don't get queries, stupid queries too. So after I have done all of that, done my due diligence, my clerk has done the search, he has done his affidavit, I compile your bundle, and I submit it to court. I mean, if you can't find a lawyer, you mean that draft the will? Well, you need a lawyer that draft the will, he's a witness?
Because you just said you probating you doing everything. So if you can't find him,
because I am awesome and people come back to me, but you can go to other people.
Okay.
Yeah.
Noted. Yeah.
All right, just keep your hands up if you have questions.
Question. Can the executor rent out the house that was left for the family to live in and pocket all the money?
No. We just said in this here, when I remember what I said, executor cannot benefit. I feel like you need to see me after. The executor cannot benefit. If they have collected rent on the asset under the estate, it goes into the estate account to be distributed among the beneficiaries. Yes, please.
The house was left to the children.
Yes.
And it was said that the person living in the home is responsible for the upkeep of the home.
Right.
But the executor is renting out that home and pocketing the money.
Bad.
Okay, thank you.
Is there a specific fee structure for the preparation
of a
will? And is it based on the value or perceived value of the estate?
No, please,
how are
not
those
at all.
fees structured?
Attorneys do it on an hourly rate. Some attorneys do it on an hourly rate. Some people do a starting rate. The average attorney, and as I always say, I don't give up my prices. You come into me, we will then, and you give me instructions, I then price you. I do not give upfront costs. Because then I might shoot myself in the foot and you bring me 3 trusts to include in that will. Ain't fair. So what I would say is, what I have heard, persons do hourly rate, and it depends on the amount of time you have been called to the bar. So when I first started, it used to be $300 an hour. Okay? So I start my timer, and $300, if you give me a lot of corrections, and I smell that shit along, man. It's a straightforward will. It's just 2 assets. Now you give me one of them 13-page wills, start my timer, and then I tell you, what's your budget? We'll be working with. How much can you afford? Because it makes sense me trying to get blood from a stone. Is this your budget? This is what we are going to do with any time frame. So I can't tell the fee structure because a young attorney may charge you $250 because they're now getting out into the field. An older attorney can tell you, man, I starting at $900 or up because that's expertise. You pay for that expertise. A mid-ranger like me, we could start wherever we need to start. Yes, please.
I'm sure this was asked, but what do we mean when we hear people talking about contesting, or somebody saying, I ain't bothering with that, I'm not contesting that will, or the person contesting the will? What exactly is that?
It means that there are questions raised about the drafting of that will. There are questions. Maybe
so
it was
if I think that I should get something and I don't get it,
yeah, basically.
I will contest the will.
There are those complaints that are frivolous. And then there are the complaints that all of a sudden someone that the testator now met owning all the companies upon their death. It raises suspicions. Or you have one child, only child, and you are close for all your life, you're close to your parents, and then they may leave you anything. They leave it to a caretaker that they barely know. Contest the will. There are questions that you want answered.
All right.
You might have mentioned this somewhere along the line
That's
in
fine.
your presentation, but what takes a will so long to be probated? People say they go away maybe
streaming
sometimes
still?
years.
We still streaming?
I mean, I try to understand it.
All right. I can answer it like this. There's a huge backlog in the court system, and there are methods being employed to ease said backlog. That's the answer I can give you right now, because I have my own understanding of that. Because let me just say this, and I'll say this in front of anybody. There's no way a probate should take me years. I am the executrix, the executor. I have given you proof that I am the person that I say I am. What the question? You understand? What's the query? What else I have to prove? Letters of administration, different, done by evidence. I have to clear off who entitled to. I have to provide a very strong affidavit in support that the court then has to exercise their discretion to say, all right, this person is entitled. There's sufficient nexus that they can come. They have the standing then to apply to the court. They fall under the act. I can understand that taking a while because there may be queries, because if you let anybody come in, anybody can then come in and run in and take up an estate. There's a certain level of a threshold of proof, burden of proof that you have to prove. Fine, but a will executor, I would distribute. Easy. When I first started practice, 3 months. 3 months to get a probate. And that went on for about a year and a half. 9 years later, that is not the case. I think the issue will always be workload. Workload. You have 1,000 attorneys, how many of them doing estates? And there's one registrar. It is a lot on her, you know? And whilst we say that, the attorneys feeling it, the clients feeling it, because a lot of those estates are attached to a sale. A lot of them have to sell to pay the attorney. So you're waiting, you can't pay a clerk, you can't pay this person, it is egregious. But you also understand that is the way the system unfortunately is, because when 4 and 5 attorneys were being called, it worked for them. Because you had as many persons submitting applications. But now you have 1,000 attorneys, you know the workload is going to pile on. But you and me both wondering, yeah?
All right.
Great.
Any other questions you have, we'll direct you to KAP Legal Services. Would you put your hands together for Miss Kimberly? Did you learn something tonight? Did you learn something tonight? Let me hear that one more time. Did you learn something tonight? All right, let's do this one more time. Put your hands together. I think this was a really phenomenal discussion. I thought the presentation was clear. I heard that you got your questions answered. And those you don't have answered, I am her appointed promoter. Anyhow, right. We're not, sorry? Well, you could talk to me and I would work things out on your behalf, right? And I'll just let her know that I send you, right? Anyway. All right, so we have one more, at least in the first part of this series. We're inviting everybody back here on July, I'm just going to confirm that date for you right now. July 16th. What's the date? Let's go again. What's the date? All right, so the 3rd, July 16th, and we're going to be looking at what's your pension plan. What's your pension plan, all right? What we've been realizing, again, as church, is that there are a number of persons that are now realizing when they're about to retire exactly how much they get in. They're now trying to figure out, persons with about 5 years or 10 years more to go, trying to figure out what else can be done. So what we want to do is try to give you as much information, and again, as we've been doing for these 2 discussions, really being practical, pragmatic, and down to earth, breaking it down so that you can get your questions answered and that we could become better stewards of the gifts that God has given to us. Amen? So just tell a friend. And again, we've been streaming, so please go to Calvary Moravian Church, our YouTube page, not the Facebook. Go on the YouTube page. Just share this presentation. Ask persons to like our page. Hello? Ask persons to like our page, but send it to a friend. Tell them, look, watch this, learn something. And of course, they can feel free to contact the presenters at their respective legal practices to get more information. Amen? Let's all stand as we bring to this act of worship to a close. And of course, as we go through, I just want to let you know that our next really major event here at Calvary is VBS 2024. We're going to do 6 weeks of VBS as we want to impact the nation's children for good and for God. Again, we're inviting persons to partner with us by way of sponsoring a child, by way of making a donation. You could sponsor lunch on a day. You could decide on Friday you just sponsor the kids. You could become a partner to journey with us. Every week is a tour as we take the children around Barbados. But I want you to also please pray for Vocation Bible School. It's remarkable the impact, and our VBS is holistic. We do have after activities. We do a number of things, so we're looking forward to your support. And of course, I must make this appeal. We need some volunteers. We need some hands to help us because many hands make light work. But as we close, we cannot close without saying some expression of thanks. Though she is one of our own, it would be remiss of me if we do not make this presentation. So we're going to ask one Kim to another. And she will just make this presentation, one Kim to another. But I'll do the speaking before I get in trouble. So, Kimberly, you have been a co-visionary with me on these topics. And this evening, we were truly blessed to hear how God has gifted you and the ability you have to break things down for us to understand. So on behalf of the pastoral staff here, Reverend Delroy, myself, the Board of Stewards, our chair is here, the Board of Elders, and all of us here, we had about 50-something people streaming on YouTube, and I know that that's going to circulate again. So again, we want to say thank you, thank you, thank you, and thank you. Would you put your hands together one more time? Let us pray. Gracious God, you give revelation and you give instruction. So God, we have heard in a way that we can understand the importance of doing a will and of estate planning. I pray, God, that that which we have been equipped with tonight, we will ensure we execute. If your Spirit has been speaking to us, give us a spirit of obedience to act. I pray, God, that for those who have to renew their wills, that they do so again being led by you, understanding the importance of generational wealth, understanding the importance of ensuring that that which they have worked for all throughout their life is properly allocated. God, we come against even now all the different types of evil things and bad-minded things that have been happening to families over these issues. Our hearts even now remember persons who are going through. We pause at this time, Lord, even though we often make all kinds of jokes and snide remarks, we lift up lawyers before you. We lift up those lawyers who work on behalf of those who are less fortunate. We lift up lawyers who are willing, like Sister Kimberly, to be honest and upfront, open and sharing with us. We pray, Almighty God, for the legal fraternity here in this nation of Barbados. We pray for the courts. We pray for the registrar. We pray, Almighty God, for the systems, even as there is a vision for the change in the modernization and updating of the respective systems. We thank you for what you have opened up to us this night. And God, I pray now that you will take each person to their home in peace and in safety. Grant us a good night's rest. And may the grace of our Lord and Savior Jesus Christ, the love of God, the fellowship of the Holy Spirit be with us all now and forevermore. And all God's people say, have a good night. Get home safely, everybody. God bless you.